All right, good morning, AP Gov. Good news today. This is the last bit of content. It's going to be kind of a lot coming at you today. You got this video, and then you got the letter from a Birmingham jail video that I put on there as well. But once you get that done, that's it. We're there. I'm going to take that review sheet that I gave you guys, and I'm going to start tomorrow going about 10 to 15 terms at a time and getting more in depth with those and reviewing those. And what you can do is what I would suggest is either on a sheet of paper or print that thing out, start jotting notes down on that, and then you could use that as you're taking that AP exam on May 11th. All right. Okay, so today's civil rights. Civil rights protects groups and individuals from discrimination based on characteristics such as race, national origin, religion, and sex. When we think of civil rights, we usually think of the civil rights era in United States history, right? So those civil rights that African Americans gained mainly during the 1950s and 60s. A key piece about that is understand that most civil rights in the 50s were handed down through court cases. The NAACP was particularly instrumental at that time. So it was the NAACP that organized that Brown versus Board of Education case. All right, they provided the attorney and such. All right, so most of your civil rights were won through court cases in the 1950s. In the 1960s, it was more legislation. So you had the Civil Rights Act of 64, you had the Voting Rights Act of 65. We'll get to that in a minute. We see civil rights in the Declaration of Independence, right? All men are created equal. The Constitution, mainly in the later constitutional amendments, 13th Amendment, civil rights, 14th Amendment, that equal protection clause has been big in establishing civil rights in the United States. And then the 15th Amendment as well, that would be civil rights, okay? Okay, just because you get those post-Civil War amendments like the 13th, the 14th, and 15th Amendment did not mean that former Confederate states were not going to try and be discriminatory. They were. They tried to disenfranchise African Americans. That means they tried to take the vote away. They tried to do this through things like the literacy test. So a test of reading skills required before one could vote. Well, a lot of these people coming out of slavery at this time could not read. So the literacy test, being that they had to pass that in order to vote, prohibited them from voting. Poll taxes, it's a simple fee required of voters. A lot of these individuals coming out of slavery, right, they're living in poverty. They don't have the money to pay the poll tax in order to vote. So that is another way that this disenfranchised African Americans. Really important, the grandfather clause. The College Board usually brings the grandfather clause into the test every year. I don't know if that's going to be the case, being that we have a alternative test this year, but it's something I've always emphasized because in years past it's been important. So the grandfather clause allowed states to recognize a registering voter as it would have recognized his grandfather. So another way of saying that is if your grandfather had the right to vote, you automatically had the right to vote. So this prevented African Americans from voting because their grandfathers, being slaves, did not have the right to vote. But it allowed illiterate and poor whites from it allowed them from having to pass that literacy test and having to pay that poll tax. Okay. So that's where you get that phrase grandfathering in. I don't know if you ever heard that in everyday language. It's these poor whites who they didn't want to eliminate from the voting block did not have to pass that literacy test or pay that poll tax, being that their grandfather voted. All right, and that's where we get that term grandfathering in. Okay, important civil rights legislation. So like I said, in the 1950s, a lot of your civil rights are handed down in court cases like Brown versus Board of Education. Civil Rights Act of 1964. All right, so this required equal application of voter registration rules. Okay, so this is saying that states have to have this equal application of voter registration rules. Therefore, African Americans can't be disenfranchised. Ban discrimination in public accommodations and public facilities. This is probably what we know best. So this is now hotels and restaurants were integrated. You could no longer have that, this is the whites only on a bus, or this is the section for African Americans. And how the courts have upheld the Civil Rights Act of 64 is that interstate commerce clause. Okay, so that interstate commerce clause, there it is again, right? Really important power of Congress. Congress is going to use it in order to pass a lot of the civil rights legislation. It empowered the Attorney General to initiate suits against non-compliant schools, so schools that were not recognizing the Civil Rights Act of 64. It empowers the Attorney General to be able to basically sue those schools. Cut off federal funding for discriminating government agencies. If your agency or maybe even a school is going to be discriminatory, you're going to lose your federal funding. Something like special education is federally funded, so the federal government can withhold that. We've seen that before when we got into federalism, how the federal government withhold money in order to get states to comply with stuff. Outlaw discrimination in hiring based on race, color, religion, sex, or national origin. You see that on most applications. If you ever go and fill out a job application, it says we do not discriminate based on race, color, religion, sex, or national origin. Probably a mandate as part of the Civil Rights Act that applications show that. All right, so there's your key provisions of the Civil Rights Act of 64. Another key piece of civil rights legislation is the Voting Rights Act of 1965. So this empowered Congress and the federal government to oversee state elections in southern states, especially those states that have been discriminatory in the past. The federal government could come in and oversee and make sure those elections were being executed fairly. And this also ended the literacy tests. Okay, Title IX. We're kind of getting into the whole gender piece in regards to civil rights. Title IX was added to the Civil Rights Act. I believe it was 1972. It amended the Civil Rights Act of 64. It guaranteed that women have the same educational opportunities as men in programs receiving federal funding. This is why colleges have to offer sports to females as well as males, okay? Because colleges are receiving federal funding, they've got to. They're recognizing that Title IX part of the Civil Rights Act of '64. Now, I would argue that most colleges today or all colleges today are not offering those opportunities to women because they see the value in it. However, Title IX just ensures that they have to. If they're going to receive federal funding, they've got to provide the same opportunities to women as they do men. College Board in the past as well emphasized the Equal Rights Amendment. The Equal Rights Amendment was something that was introduced early in the 1920s. That's when you start to see the women's rights movement in regards to suffrage and all that. The Equal Rights Amendment, it's been around for decades. So introduced in the 20s, they even took a vote in the 70s. It passed at the national level. So it passed that proposition part, right? So for an amendment to happen, there's got to be that national, like Congress, 2/3 of Congress has to support it, or 2/3 of the states through these conventions. That's never been done before, though. But the 2/3 of Congress has to support it. Then it's got to be ratified at the state level. It's 3/4 of the states have to ratify it. This amendment basically said equality of rights under the law shall not be denied on account of sex. It gave Congress the power to enforce this. This would have made it really easy for Congress to ensure things like equal pay in the workplace. All right. It failed in the 70s. It passed at the national level, but it just was not ratified by the states. Why did it fail? There was some of those traditionalists that said, hey, what's this mean for the military draft? Does that mean that we're going to draft women as well? Some people thought it could be hurtful to women in regards to alimony, so they felt like it would actually strip some protections when it came to divorce from women. And some people argue that this was possibly a backlash to Roe v. Wade. Roe v. Wade, early 70s. This is considered a big-time achievement for the women's rights movement, that court case. And some people argue that the other side simply just voted down the Equal Rights Amendment because they were upset about that Roe v. Wade decision. Okay, affirmative action. So this is a label describing institutional efforts, so schools and governments, to diversify based by race or gender. Colleges and federal contractors take steps to ensure diversity. All right, so if you apply to college, they're going to ask you what your race is. Depending on what your race is, your application can be emphasized through a point system because they're trying to bring more diversity into their college campus. All right. President Johnson said, "You do not take a man who for years had been hobbled by chains. Liberate him, bring him to the starting line of a race, saying you are free to compete with all others." All right. So colleges will put emphasis on trying to bring minorities into their into their colleges. Federal contractors will as well. So when the federal government will award a particular company or business, hey, like we're going to pay you to build this bridge, the federal government, if the federal government feels like their workforce is not diverse enough, then the federal government may not reward them with that contract. They'll give it to another contractor whose workforce is more diverse. That's where we see it in federal contracts. Supreme Court and affirmative action. Obviously, these cases have been brought to the Supreme Court. They've been brought to the Supreme Court through the Equal Protection Clause of the 14th Amendment. Mainly, it's been backlash. Basically, those in the majority group, whites, basically saying this violates that Equal Protection Clause. How can somebody, just because they're of another race, be accepted to the university when my application was stronger than theirs? And here's what the Supreme Court has said on the issue. The Supreme Court has said, and they ruled this in the Regents of the University of California versus Bakke. You may remember this case from U.S. history because it is an on-level U.S. history standard. Basically, what the Supreme Court has said is colleges can emphasize applications from minorities, but what they can't do is have a quota system. So if your college is going to award 10,000 acceptance to 10,000 applicants a year, the college can't set aside 2,000 for minorities. All right, so the quota will violate the Equal Protection Clause, but emphasizing those applications, giving them points based on race is okay. That is what the Supreme Court has decided on affirmative action. Okay, strict scrutiny. I don't think this shows up on the test. It's kind of complicated with civil rights legislation, with states passing laws that will emphasize race or something like that. Strict scrutiny is just the idea that the Supreme, and you don't really need to write this down. I'm just kind of covering all our bases here. Strict scrutiny is the idea that the Supreme Court, if there's any law that classifies by race, the Supreme Court's going to pretty much consider it dead on arrival. In other words, the Supreme Court's going to say, you better do a really good job of saying why there is a public interest in the fact that you have singled out a group based on race or religion or national origin, because you're going to have to pass this strict scrutiny test and show us that there is this public interest of why this law needs to exist. So in other words, the Supreme Court practices this idea of strict scrutiny, being that any law that specifies a class of race or national origin is going to receive this very strict scrutiny. You're going to have to remove heaven and earth and basically prove to us why there is a public interest in having this law. All right. Okay, that's it. Again, I don't think strict scrutiny shows up on the exam. I'm just kind of getting into it just to cover all our bases. Go and watch the MLK Letter from a Birmingham Jail video. That's going to wrap everything up. And then in the coming, for the rest of this week and the coming weeks, I'm going to start getting into that review sheet. Highly recommend you print that thing off, write down what I say. And then also, I will get the FRQ to you guys that's going to be due this week by tomorrow. It's going to be a concept application, so it should be pretty quick. But that's it for today.